My name is Anthony Mauriello. I'm a solicitor in the commercial team at Johnson Withers Lawyers, and today we'll be talking about tenants' breaches of a commercial lease. Unfortunately, many landlords will experience a breach of a commercial lease by a tenant. This can involve non-payment of rent, damage to property, or other such breaches. The landlord will find that they need to take specific action to remedy the breach, or they are otherwise exposed to risks of counterclaims or other negative consequences in response to their actions. The first step is to identify the breach that has occurred. Almost every lease will have a covenant that a tenant is to pay rent. So, for example, that would be the breach in this instance if the tenant is not paying their rent. The next step is for a landlord to serve a notice to remedy breach. The service of the notice must be in accordance with the lease, and there are very specific steps and specific details that must be included. It's important that a landlord provides a reasonable time frame for a breach to be remedied. There isn't a blanket rule of what that is. It depends on the circumstances, and that's something we can assist with. For example, if rent's just owing, 7 or 14 days may be reasonable. If substantive works are required to the premises, that may not be reasonable. There is no prescribed form for the notice to remedy breach. However, it must comply with the requirements under the common law and in certain circumstances, Section 10 of the Landlord and Tenant Act. The notice must be in writing. It must identify the parties. It must identify the lease and other particulars surrounding the lease. It should identify the breach and the particulars of the breach. It must set a reasonable time frame for the breach to be remedied. And it must put forward if the landlord's intending to re-enter the premises. And finally, it should be signed and dated by the landlord. A common and effective remedy utilised by a landlord for the non-payment of rent is the distraining of goods on the premises. This involves the landlord entering the premises, seizing goods, and selling them by auction to obtain the best possible price. This can be an effective remedy when rent's outstanding because it allows the landlord to quickly recover the costs. The landlord can also recover the costs of legal costs, bailiff costs, and auctioneer costs. However, this can be a complex remedy, and we are able to assist in the relevant documents that need to be provided, the notice that needs to be given to the tenant, and other considerations. There are a number of important considerations the landlord should give weight to when exercising this right. For example, the right cannot be exercised when a lease is terminated or has expired. The right only applies to the amount of unpaid rent, so that's not other outgoings or GST or any other amounts payable under the lease. All goods can be seized and sold. However, there are certain exclusions, for example, clothing and medical records. And there can be very serious consequences for a landlord who does engage in this remedy without following the proper protocols. For example, if a landlord does seize and sell goods, and then it's determined that they didn't have the right to do that, they can be held liable to pay to the tenant double the value of those goods. Every commercial lease ought to have provisions included which relate to the landlord's rights to re-enter the premises. This involves the landlord again serving a notice on the tenant. It must comply with the common law and it must comply with Section 10 of the Landlord and Tenant Act. It sets out the reasonable time frame for a breach to be remedied, and if the tenant fails to do that, then the landlord has the right to re-enter. Once the landlord does re-enter, the lease is effectively terminated. And there are, again, very specific forms, timeframes, and procedures that must be followed. There can be very significant consequences for a landlord that re-enters a premises incorrectly. A landlord may also take legal action to recover damages incurred due to a tenant's breach. This can be for rent owing, future rent, outstanding outgoings. It's also important to consider that a landlord has an obligation to mitigate its loss. So a landlord should, let's say a tenant has abandoned the property, the landlord should be trying to find tenant and doing all things possible to mitigate their loss. If a landlord is successful in obtaining judgment, there are various orders that can be sought, warrant of sale, for example. A landlord may also have other various remedies, but these will depend on the terms of each specific lease. These include a bank guarantee, a director's guarantee in the situation where the tenant is a corporate entity. The landlord may have the right to secure a charge, which can include a registration on the Personal Property Securities Register. But in my view, the most important step for a landlord to take to protect itself is to have a properly constructed and drafted lease The lease should include what's to happen when a tenant is in breach, what remedies are available to the landlord. This can include default interest and the other mechanisms which come into effect when a tenant has breached that lease. It is worth knowing that the remedies we've discussed today apply generally. There was a period recently which did affect this. That was during the COVID-19 period. During this period, from 30 March 2020 to 3rd of January 2021, the COVID-19 Emergency Response Act and the Mandatory Code of Conduct was in place. This basically prevented a landlord from enforcing any of those remedies to a tenant who was affected by COVID.